Hi, and welcome everyone to the third webinar in our anti-demand series. This one is civil litigation, trafficking, and demand. And today I'm so excited because we are joined by two of the best trial attorneys in the nation, Pat McDonough with Anderson, Tate & Carr in Atlanta, Georgia, and Annie Mcadams with Annie Mcadams PC in Houston, Texas. Both of these attorneys not only represent trafficking victims, they're among the very first to ever have taken this work on and to have taken it on successfully. Today's presentations are going to be chock full of information that is useful and interesting to everyone. You definitely do not have to be a lawyer to be here. Both Pat and Annie are accustomed to breaking down complex legal concepts for a lay audience, and they're going to do it in a compelling and meaningful way, and that's what they're going to be doing. That's what they're going to be doing here today. But if you are an attorney, you're also going to get some really deep insights into how these cases work that can help your practice. And we're going to end with a quick policy briefing that I'm going to do. I'm going to spend just a few minutes going over some key statutes that can help ensure that your state, no matter where you are, has a statutory framework that's going to be conducive to survivor recovery when it comes to civil litigation. Before I go any further, I want to be sure and thank our fabulous co-sponsors, the National Center on Sexual Exploitation and Global Emancipation Network. I want to thank them both not only for the fantastic work that they do every day, but particularly for helping us bring this series to the public. We literally could not do it without you guys. Thank you so much, NCOSE, and thank you so much, Global Emancipation Network. Now, a couple of real quick housekeeping notes before I get started. We have a question tab or a button at the bottom of your screen. That's where you're going to type in your questions that you may have for any of the speakers. We're not using the chat, so put your questions in there. At the end of today's presentations, there's going to be a QR code that comes up. We're going to ask you to please just scan that real quick with your phone. That's going to take you to a survey. I promise it's a real quick and easy survey, but if you fill that out, it really helps us know what you liked, what you didn't like, and helps us plan to have the best webinars going forward. And last, both Pat and Annie are they're both going to be going into litigation and litigation strategies in depth. And that's going to include cases that they've won or cases that have settled, but it's also going to include current cases that are ongoing. And they may name some defendants. So please keep in mind, with respect for cases which are still ongoing, a lot of what you hear they're going to be allegations, and liability with respect to those defendants has yet to be established in a court of law. Now, without any further ado, I'm going to introduce our first speaker, Pat McDonough. Pat leads the Civil Sex Trafficking Division for Anderson, Tate & Carr, and for the past 4 years, he has specialized in this area of the law, and he's filed over 20 lawsuits against hotels which have been complicit in exploiting victims, and these were the first lawsuits of their kind in Georgia. Pat recently won the largest public sex trafficking settlement in the country against a hotel. He's amassed a top-notch team of lawyers who are dedicated to pursuing these cases and seeking justice for survivors. His team works closely with complex trauma therapists and experts on each case. And before joining Anderson, Tate & Carr, Pat was the youngest district attorney in the state of Georgia. So please join me in welcoming Pat McDonough.
Thank you, Jamie, for that introduction. And I look forward to presenting kind of what we do as a civil lawyer in fighting the sex trafficking and what we do in the movement of the anti-sex trafficking movement. In particular, what I do and what my firm specializes in is we look about how we can sue different hotels and motels. And so if you look on the screen, I know most of the people in the audience here are familiar with the trafficking movement and understand clearly how it works. But I do like to highlight just the basics of how sex trafficking works here in the United States and why we think it's so critical to target the hotels and how that can affect demand. I mean, essentially what trafficking is you have a trafficker who is selling a product, right? Sadly, the product is typically a child or a young person or a person that is controlled, kind of a modern day slavery type thing. But the trafficker ultimately is selling that person for commercial sex over and over again. The victim, who when they pull themselves out of it become survivors, are essentially a product, right? They're sold over and over again like a product. And to sell a product, you sell it to a buyer, right? So the buyer, or sometimes people use the language of a John, comes in and buys this commercial sex. So that's the kind of the triangle of what sex trafficking is. But all this has to take place somewhere, right? So where is the venue? Where's the market for this sex trafficking? Or what I refer to a lot of times is the crime scene, right? And that is often a hotel. It's not always a hotel or a motel. And certainly sex trafficking can happen in houses. It can happen in warehouses. It can happen in a lot of places. But not only do I think the statistics bear it out, but here's the bottom line. The buyer wants to go someplace that he or she at times thinks that it's safe for him to buy commercial sex, right? So a hotel and a motel gives them that. Typically, the ones that we end up suing are usually off of an interstate. My practice is primarily in the Atlanta area, but I understand this is a nationwide kind of phenomenon. And so they feel comfortable that they can pull off the interstate, pull into a hotel, go into a motel room, engage in the commercial sex, and then leave. A lot of the buyers, they don't want to go and meet somebody in the woods. They don't want to go to some scary part of a city, into some, abandoned building or something. And they really can't go in a lot of neighborhoods. If someone tried to run a sex trafficking operation out of my neighborhood, in my cul-de-sac, it would be a matter of hours where my busybody neighbors would have already identified something that's going on, called the police, and shut it down, right? And apartments can often be like that too, though apartments are used at times as the crime scene of the market for sex trafficking. You have longer term residents there that see things a lot faster. At the hotel, your only really line of defense is the hotel employees, the people that are working the hotel, the front desk people, the staff people. How do they combat that? And so what we found is that to make this work for their business model, a couple things have to happen. A hotel, again, as I said, provides a perfect market for the buyer to come in and feel comfortable. But the second thing that's got to happen is the trafficker wants to make money, right? So the trafficker wants to sell his product, sell his person over and over and over again. And that's how they make their money. So there's really only two ways that they can do that. They go to a hotel that is either complicit, right? And that means they're in on it, right? That they know what's going on, and that either they're getting paid off or they're being a lookout for them, and they tell them when the police are coming, or they at least turn a blind eye, right? Things are so bad that they just look the other way. I put on my slide here, part of this is usually connecting the buyer to the sellers. Often there's online advertisement, and I think you've either heard from her, you're going to get to hear from Annie Mcadams, and she will talk to you about how she is targeting that and how that can help lower demand. But if we can take away this market, right, this easy place where a buyer can go to a hotel and engage in this, and we can make it much more difficult, we can really decrease demand. And I think we can decrease it, on a really a national, if not global scale, right? Because the hotels, you have national chains and you have hotels, and as soon as their bottom line is hit with one of these lawsuits, they're gonna change their actions, right? If they're willfully blind and they're just saying, I'm gonna make the money, right? I'm gonna make the revenue, and there's no consequences to them. There's no incentive necessarily financially for them to do that. I'll give you I'll give you two examples of cases that I have currently, just so you understand. We're not talking about a hotel where one person sneaks in around the back and nothing's going on. We're talking about hotels that literally it's part of their business model. I've gotten sworn testimony from the front desk operator of a hotel that says they know the traffickers, that they have hung out with the traffickers, that they warn the traffickers if the police are in the parking lot, that they know who the victims are, and that they know that these victims are being trafficked. And it's not like a close call, that if you look down the basically from the hotel down to the end of the, from the office to the end of the hotel, that there's literally at times 10 different people that are working, that are victims, that are being sold, that there's multiple traffickers all over there. And in a day's time, you might have 100 buyers coming through that hotel, 100. So clearly the hotel either knows about it, right, or is turning a blind eye. I'll give you another example of how high this can go. I have another hotel where the hotel operator says, it's just part of the business. This is the front desk person. He says, I've got young people that are getting dropped off by a trafficker. Sometimes he stays, sometimes he leaves. Says it's been rotating him in and out there for the entire time he had been there, about a year and a half. He says towards the end of his time, though, they started getting complaints because these victims were literally 13, 14, young, right? And they're getting complaints from other people by them, whether it be noise or whether it be what they were doing. And so this person who's making $12 an hour at the front desk calls corporate, because it's a corporately owned hotel, national brand, and says, you know, what do you want me to do? And they say, just move them to the back. They literally say, just move the children to the back. You see, that way they can make money on the back with their regulars, and then they can put other guests in the front. And this has just gone unchecked, right? That there's been very, very little attention at this market. But if we can financially hit them in their bottom line and realize that that's not a good business model for them, right? That they can actually be held accountable for that, then we can ensure that they're trained, and they can ensure that when a front desk person sees that, they don't even have to call corporate. You know, they know to immediately call the police, right? They know immediately what the signs are of trafficking and what to do. So we believe that going after this venue from a national scale will have a trickling effect, right? Not only do we, you know, individually we represent these survivors, and we absolutely hope that we can get just compensation for them, so you know that they themselves can turn their life around. We think it's going to make just a huge impact down the road. And I will tell you that my experience with my survivors and my clients, the money is important for them, but to a person, they are more interested in being involved and actually risking their own re-traumatization by having to tell their story if they can make a difference, you know, for the next little girl, right? And the next little boy, that they can actually help, that this will send that message that hotels can't do this. They can't make money and do that. So, you know, is this a small biz problem? Is this a big problem? You know, these are just a few little statistics that I pulled out, but it's big business. I mean, in Atlanta, this is back in 2014. So this one statistic I have up here, you know, it's 7 years old, but they were saying just in Atlanta alone, it was a $290 million economy, right? So that's rampant, right? Throughout the hotel industry. They were talking about traffickers and pimp could make up to $30,000 a week in one of the studies that was done. You know, my own experience with clients that I have, it might not be $30,000 a week, but they're making a lot of money. It is a financially lucrative thing for a trafficker to sell a person at a hotel if the hotel doesn't get them arrested, right? If the hotel is going to call and get them arrested, it is not financially lucrative. So it's a big business, and you know, business needs to be hit at their bottom line. Again, kind of what impact are we looking for? Obviously, what we hope to do is we hope that our survivors are able to write their life, right? And take this and get the right kind of treatment and do those type of things. But what we really hope is for systemic change, and that is to change the hotel behavior, that when they see that sign, they call that police officer and the person gets rescued. And then it's known that don't come to this hotel, right? It becomes, you know, nationally known that this is not where we're going to let you do that type of business. And we think that will drive demand down, and you know, will make a societal impact. So I'm a lawyer. How do we do that? And there's different ways to do it, different legal claims throughout the country, but and I'm not going to spend a lot of time on negligence, but just the good old fashioned negligence has been around forever, right? Is certainly a legal theory that we use, and we've been successful. We have settled cases against hotels, you know, in the millions figures, just by saying they owe a duty to their guest, right? And if the guest brings a victim, they owe a duty to that victim, right? That if they breach that by turning a blind eye or allowing trafficking going on, then that would be a cause of the person being trafficked. Clearly there's damages there. So this is a traditional kind of legal theory that has been used, and not in this arena that much, but it's been used in a lot of arenas, and it can absolutely be used here. And we believe we proved that model in Georgia anyway. The TVPRA is the Trafficking Victims Protection Reauthorization Act, which I'm sure a lot of you've heard about. And that is kind of our go-to, because that is exactly what this federal law was intended to do. It was originally to make trafficking a crime. Then it was to allow victims or survivors to sue the trafficker, and then ultimately allowed us to sue businesses that were profiting off this. And then a final thing is Rico. And Rico, there's a federal statute, there's a Georgia statute, and then there's obviously other different state statutes of Rico. So you'd have to look at your particular state. But Rico can be a very powerful tool, we believe, in going after these hotels too. So I'm not going to go any further into negligence, but the TVPRA, I did just want to, for anybody out there who's interested in kind of the legal way to do that, basically one of the most powerful things that happened with the Trafficking Victims Protection Act is it gives you a 10-year statute of limitations. Obviously, our survivors, they don't just get rescued and then say, oh, let me go talk to a lawyer. So it takes time and healing for them to get there. And that statute doesn't start until they turn 18. So it gives us a long time to really bring these claims. And again, I won't go into all the details, but this act made it a crime to traffic, a minor, or if they're an adult, if you use force, fraud, or coercion for commercial sex, they're trafficking. There's 3 different types of ways you can do it, but the bottom line is we believe it's kind of a negligent standard, that if you can prove 3 things: the hotel made money, that they participated in this in some ways, and they knew or should have known that this was going on, they can be liable. Kind of the premier seminal case that started out was this case called Rico, and essentially a trafficker and a hotel owner were seen high-fiving each other, saying, let's get this business going. And it was the first case that kind of came out of the First Circuit that said, a hotel can be liable for that. So people started following that. My case, that was just a local hotel. My case was one of the first in the country. I think the first in the country that we tried to go after a franchisor. And there's always a question of what do you have to prove to get the national franchisor brand in? And what we learned from this case is room rentals meet the financial benefit. And but to participate in a venture, you have to do more than just send someone down once a year and have a few bad reviews, right? So we've got cases where we have direct emails going to CEOs. We have cases where we have reviews of hotels that went to the particular people at corporate and at the franchisor that we think will be enough. But that's still kind of in litigation and not there. Georgia Rico, and that's the one I'm going to use, but there's similar Rico statutes throughout the state, but I'm just going to go over Georgia since that's the state that I'm in. Again, it's got a 5-year statute of limitations, so it's a little longer than a traditional negligence, so it gives you some time. And here's the thing about Rico. It's very similar to the TVPRA. It's just kind of drafted differently. If a hotel or a business gets money, right? They obtain money, so they rent room through a pattern of racketeering activity, they can be liable. So you ask yourself, what do you need for a pattern? Well, you only need 2 acts for a pattern, right? So then you ask yourself, I'm just gonna skip over that. You ask yourself, well, what is a racketeering activity? And one of the specific racketeering activities is trafficking a person for sexual servitude. So if you're already proving that there's trafficking there, then you have an ability to prove that Rico applies. But what's really interesting about the Rico analysis is if you are keeping a place of prostitution and someone is trafficked, you can be liable for Rico. And this is very powerful because what a lot of the hotel lawyers will say, and they kind of their defense is, well, we might have known there was prostitution going on, but we didn't know anything about the trafficking, right? And so if they know, obviously that's where a trafficker is going to go, a place that he can bring his victims and not be noticed, right? And try to blend in with prostitution. And so if they're keeping a place of prostitution, that can actually be considered a predicate act. Now, to keep a place of prostitution, they have to knowingly do this, right? And that's a little bit of a higher standard. So, you have to really have good evidence of that. But if you do have good evidence of prostitution, then essentially, or as I said, sex trafficking, then anybody has a cause of action. So essentially, if someone comes in and we prove the hotel took money and they were keeping this place of prostitution, if our client was there and was trafficked, then they would be a victim and they would have an ability to bring a civil action. And one of the powerful things about Rico is you get treble damages or triple damages, and they have to pay attorney's fees. It's a shall have to pay attorney's fees. So it's a powerful civil tool that can be used when you're trying to go hold a hotel accountable for this. And so at this point, I'm just going to throw it back to you and see if you've got any questions for me.
Thank you so much, Pat. That was a fantastic presentation, and I think everyone has learned so much. The audience has, we have a lot of questions coming up. So if you've got a few minutes, I'd like to hit you with some questions.
Sure.
So the first one is, and I'm partial to this question myself, what state policies would help, further the cause of civil litigation, allow more and more effective civil litigation to take place on behalf of trafficking victims?
Well, it's all state by state. In Georgia, what I think two of the most important policies they could change is kind of how their state statute is involved with trafficking. As I mentioned earlier, there's that federal TVPRA. In Georgia, they did pass an anti-trafficking bill, very similar, kind of modeled it after the federal statute, and it went into effect last summer. So anybody who is trafficked after July of last year going forward, they could actually bring their case or their claim in state court. But as you know, being in this movement, people don't get trafficked and then 2 days later decide, oh, hey, I'm going to go see the hotel, right? So what I think would be important is that they have what people typically refer to as a look back. And that would allow you to go back and say, hey, if I was trafficked 5 years ago or 10 years ago, I could still bring my case under this statute. And it's not something new to Georgia. Georgia did it for a year. They did this 1 year where they allowed the Boy Scouts, anybody who was thought they were a victim of the Boy Scouts. There's been other cases around the country with the Catholic Church where they'll set it up for like a year and say, all right, anybody out there who thinks their case is too old and they want to do it, we're going to give you a year to look back to bring that case. And I think that would be very powerful to allow people to fight their case in state court and to do that. The second policy thing I think is important is punitive damages. In Georgia, for example, our punitive damages, we have a cap at $250,000, right? There's a lot of people and there's arguments on both sides on why you would cap that, right? You don't want to put businesses at a business and there could be these big verdicts. But in Georgia, they have an exception to products liability because they say, you know what, we don't want big companies coming here and selling products that might be deficient. If your stroller's deficient or the seatbelt snaps or something, we make that exception for products for the safety of our citizens. There's no cap. I believe that they should make an exception for survivors of sex trafficking, right? And what you should be able to do is hit a business that is profiting off of this sex trafficking to actually be punished, right, by damages. So you can tell a jury, if you want to send a message and make that message big. Because the whole point behind, well, not the whole point, one of the major points behind civil litigation, right, is not only getting compensation for our client who is trafficked and is damaged, but it's to tell the hotel industry, look, you're being punished for allowing this to go on. You're being punished because you turned a blind eye and allowed these children to be sold over and over, right? Not only you, but guess what? Nationally, that gets picked up on the ticker, right? Everybody at the next hotel conference says, we better make sure that we take this training or, these prevention matters pretty seriously because you could be hit with this big verdict. And then we think you get a wave of systemic change. So I would say those would be the two most important policy changes that you can make in Georgia.
That's great. That's a great answer. And, we're seeing more and more hotel training come up as an issue, but like you said, if they need to be incentivized to actually implement it seriously in an effective manner, right?
Yeah, and I don't mean to cut you off, but just to follow up on that point, training is great and it's important. And there's a lot of volunteer organizations go out there and they might even meet with the hotel organization and they have training. But one of the things we've learned in our cases are, do they have to check a box and say they watched the video for an hour, right? Or is the hotel saying like, this is something that we're taking seriously, right? So if a hotel realizes that they could actually be sued and it could hit their financial bottom line, right, then they want to ensure that their people are doing that, right? So I give you an example. I had a case not too long ago, and I deposed the owner of the hotel. He lived at the hotel. He stayed there, and he said, I train my people all the time. Sure, I got the training at this hotel, and I do that. And then when I deposed all his employees, they didn't even speak English. So, I mean, he wasn't really training them, right? But he had something up on a web about training and stuff. So if he gets hit and he goes to the next, hotel seminar, they're going to be able to say, like, look, you better take that training seriously, right? Like, you better be able to have your employees say they know what that training is. Because I promise you, the civil litigation, I'm going to ask them, what were you trained? What did you actually learn that? What did you do about that? Because the goal is not to get people to have training videos. The goal is for people to actually identify and prevent sex trafficking, right? I mean, that's the goal of the training.
100%. So our next question, and I'm curious about this myself, is have you ever sued a buyer?
I haven't sued a buyer, and it's not that I'm opposed to suing a buyer if the right circumstances lent itself, and that would only typically be if the police had gone in and actually done a sting or done a bust, and they actually caught the buyer kind of right there, right? Or there was a way to track the buyer down. I wouldn't have a problem with doing that. It's harder to do that because those are, again, it's like suing a trafficker. Like, does the buyer have deep pockets enough to pay the survivor, or are you just suing someone to sue someone? You don't want to re-traumatize someone just to sue someone, right? So they would have to be a buyer that actually had deep enough pockets to make it make sense to do it, and you'd have to have the evidence to do it. Again, where the kind of bigger impact when you hit a hotel or a business that's profiting off of it, as I think I mentioned earlier in my talk, I know hotels that we have people saying every day they might be having 100 buyers, right? So we're trying to do something that spreads, that stops 100 buyers a day, not just, hey, I got one buyer, right? And again, it's not that I would be against it. It's just, it doesn't make as much of an impact or make as much sense. One of the things I will say about buyers, though, and how the criminal can cross over to civil is if a buyer buys commercial sex of a minor, someone under 18, that is actually trafficking, and they can be criminally prosecuted for that. And our Attorney General has recently indicted a number of people. Your very own person in your own office that used to be a prosecutor prosecuted a buyer under the trafficking statute. And one of the things that's important about that is this. We often hear the defense say, or hotels say, well, we might know about prostitution, and then, they know what they're doing, and we're totally against sex trafficking. But that means they're making some cognitive decision that, hey, that person over there is over 18 or under 18, and then they're voluntarily. Whereas if they were taking the position that, hey, we're against crime and we're going to call the police, and the police came in, they might be able to rescue somebody who is being trafficked there, right? And what we can say is it is trafficking if someone is a minor, right? So you actually need to be aware of that when you're training and what you're doing. So it's still a very important part of kind of the civil litigation, even though we don't necessarily sue the buyer typically.
That's a great answer, Pat, and it's a lot to think about. A couple more questions if you've got time, or at least one more question. I want to talk a little bit, something our audience might not be as familiar with, but is very important in civil litigation, and that's liability schemes. Can you talk about how important liability schemes are at a state level when we're talking about this kind of work?
Well, it can be important because in Georgia, for example, they can apportion fault, right? So you could go sue a hotel that is clearly making a lot of money and profiting against this, and they could say, well, we're going to apportion 50 or 60 or 70 or 80% of the fault to the trafficker, right? And so then what happens is whatever damages you might recover, you're likely not going to be able to recover anything from the trafficker. Right. So if you can have a scheme that is joint and severally liable, where they basically, whatever the amount of money is, whether that's $100 or $100 million, that the person who has the money has to pay it. They can always go, the bad people can go fight amongst each other to try to collect and make sure they're both equally paying, but the victim or the survivor gets to pay. So it can make a difference. And there are even decisions on whether we file in federal court or state court sometimes can drive that, right, on how those laws are laid out as far as apportioning fault.
And our last question, you mentioned a couple of times the importance of bringing a case in state court, or the advantages to bring one of these cases in state court. One of our audience members would like to know, what are those advantages? Why do you want to bring these cases in state court?
Well, there's a lot of reasons, but I think the most fundamental reason is this. I think it's a community problem that needs to be fixed by the community, right? So what I believe is the victim who then becomes the survivor was trafficked at a hotel in their county, right? Whatever county that is, I believe that those jurors should be from that county so they know what their hotel is doing, right? I believe the judge that's elected should be from that county. I believe that the victim survivor has a right to come into their community and say, we don't want to put up with this. And I think a jury can say, we're not allowing this in our community, right? When you go to federal court, and they're different states, but in Georgia, there's 3 different districts. So you get a third of the state, right, that you're going to a federal court. So your jury pool is different than what your local community is. And I think the best way to fight these things is, community by community. And so I almost always would go to a state court if I could. Why I generally go to federal court is because of the 10-year statute of limitations, right? I have someone that was trafficked 8 years ago, and I don't have an ability to bring it in state court. So I go to federal court. But if I had the ability, I would probably bring it in state court 90% of the time.
Well, thank you so much, Pat, for these enlightening answers and for your fantastic presentation. And we thank you for the work that you're doing on behalf of trafficking survivors and to help eradicate this problem in a systemic manner by eliminating the places where it's the most prolific. So thank you so much for your time and expertise today.
Yeah, thank you for the opportunity.
We're going to move right into our next presenter, and that's Annie Mcadams. A little bit about Annie. For her entire career, Annie Mcadams has exclusively represented plaintiffs who have been the victim of injury or harm due to the negligence or acts of others. After working with Steelman and Mcadams for 10 years, she formed Annie Mcadams PC on the premise of providing exceptional legal services to hardworking people. Her practice focuses on representing those who have been survivors of human trafficking, killed or seriously injured in major trucking and motor vehicle accidents or by dangerous drugs and medical devices, or whose lives have been seriously disrupted or even destroyed by the bad faith conduct of an insurance company. Annie is a graduate of the University of Texas and South Texas College of Law. I will tell you that we have followed Annie's career for a number of years, so deeply impressed with how she handles these cases and the fact that she really takes a holistic view of this area of the law, and she is dedicated to making the best case law possible so that more of these cases can come forward and more survivors can be restored. Thank you so much for joining us today, Annie.
Thank you so much, Jamie, for allowing me to be here. And thank you to Street Grace. On behalf of myself, as well as my team, we are such big fans of y'all's work. And it's an honor for us to be here to talk to y'all about what we've been working on the past few years. My name is, as Jamie said, Annie Mcadams, and I'm the lead trial counsel in the anti-sex trafficking efforts, both against the hospitality as well as the tech industry in general. And I'm going to talk a little bit today about how we got involved, because I think that kind of helps put color on the paper on what these cases are really about. I will share with you all, I was a trial lawyer practicing in Houston, Texas, and handling personal injury cases, and truly back in 2017 had really no idea what sex trafficking really was, or human trafficking in general. I knew the terms. I knew that it was bad. I knew that, it's kind of hard to admit, and to be completely candid, I really didn't fully understand what it was. And I thought that it was always involving international travel of some kind. I didn't know that this was something that was happening right here next door and in our backyard, in our communities. And in 2017, I was first approached by a few criminal defense lawyers here in Houston who said, hey, we're representing some of these individuals who have been charged with prostitution, who are not in fact prostitutes. I was actually driving back from the Conroe courthouse when they were talking to me, and I was, and they said, and we know that there's this new statute in Texas, and it wasn't really that new at the time. It was actually passed many, many years before, but had never really been picked up and filed on. And I said, we really want you to take a look at these civil human trafficking cases. And I'll admit, it was about 3 months. I said, no, I don't think I'm the right lawyer. I wasn't looking for a new docket. But their persistence in saying, just take a look at this case, and explaining to me what force and fraud and coercion look like, to explain to me how, as a matter of law, if it involves a child, it is sex trafficking, as a matter of law, and what those things meant. I was a slow study, to be very candid with you. I didn't really understand it. But it was after looking at some of these cases and the persistence of these criminal defense lawyers that were completely convinced that we were the right team to take a look at the civil justice aspect of these cases. I knew it was something we had to take a deeper look at. And it was the summer of 2017 that we started to really look and talk to law enforcement. Houston is known for an incredible law enforcement effort in anti-human trafficking cases. Texas, a lot of people want to say a lot of things about Texas and their politics. One of the things that, is a good thing in Texas that's happening is the anti-trafficking efforts legislatively, dating all the way back to 2009, when we started to see the Texas legislature take these civil initiatives. And one of the things that we started to recognize that the legislators and law enforcement are fighting this endless battle and really had virtually no support from civil justice at that time. And so you see, Mr. Crothers, way back in 2009, had this vision that if we are really going to start to make inroads and fight in the fight against human trafficking, that civil justice is going to have to step up and address the business's roles in human trafficking. So back in summer of 2017, when we were looking at these laws that the Texas legislature had designed, but nobody had ever picked up at that time to address some of the other forces in the sex trafficking and what was developing in sex trafficking at the time, we knew that when we were going to put the first case on file, that it was a big deal. And it was something that we really had to focus on making sure was done the right way. We knew that the hospitality industry, as well as the tech industry, was not going to just sit down and accept it very easily. And that if we were going to do it, that it had to be designed in a fashion that was really going to go the distance. Not only because we have an obligation and the importance of the case to our client, but also the community as a whole, the anti-trafficking community. What law enforcement has done to fight this has been tremendous. But how can we support them in their fight? How can we support the teams like Street Grace and Jamie Crothers in their efforts to make sure that we're doing their work justice on the civil side? So we started reviewing cases, and I think that this is really important part of what I'm talking about today, because I think that it really put the pieces for me together. I started to interview potential clients. Who is going to be the first Jane Doe that we filed? At the time, it was solely going to be against the hospitality defendant. But as we started talking to these families, as we started talking to these survivors, we started to recognize that there is something that ties them all together. And it wasn't just the horror of what they had endured, but it was in fact the role of technology and social media in their exploitation. So as we started to talk to families in California, or whether it was New York, one thing that was very, 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 very common was the recruitment, the grooming, sometimes the sale, the facilitation of their trafficking through the use of social media. So what started as looking at the hospitality very quickly said, wait a minute here, we need to take a look at the role that big tech is playing in the facilitation of sex trafficking. We started talking more to law enforcement. And of course, law enforcement, we all know about Backpage, or like me in 2017, had no idea what Backpage was. But they all said, yes, we go to Backpage, but it doesn't always start there or end there. And then we started to look at the accounts and the grooming that was occurring, whether it was Facebook, Instagram, Snapchat, all of these platforms that we were really looking at for the facilitation of these crimes. Now, the problem then became, why has this not been done before? I mean, that's the lawyer's first question is, why hasn't somebody done this? It's so obvious. Well, we had seen and immediately went to the books and the records in Westlaw and started to see that, yeah, some of it has been tried. In fact, some of my colleagues here in Houston, right down the road from me, filed a case against MySpace in Dallas, but it was dismissed. And it took me all the way back to a case talking about the Communications Decency Act. And it was a case in 1996 Now I'm looking at these cases in 2017, and yet we're looking at a law from 1996 and a case from 1996, the Zarin case. And there is a lot to be said about the Communications Decency Act. A lot of people would like to blame the Communications Decency Act for some of the problems that have happened with tech. And we're going to talk a little bit more about that shortly. But when I was looking at the history of the law, you really started to see that there were no inroads made into responsibility of tech. Nobody had really ever passed up a motion to dismiss in a tech-related tort case. And so we really were taking a hard look at why, what was this? And also trying to tie that into how tech played the role in the facilitation of this sex trafficking. And we very quickly knew that our eyes were on tech. We went ahead and filed the very first comprehensive anti-sex trafficking hospitality case with our eyes fixed on Facebook. We knew that Facebook was going to be one of our first defendants. Going back to the law and the Communications Decency Act at this time, when we drafted the first our first petition against Facebook, the very first thing that our team does is meet with our appellate lawyers, and our appellate counsel, agreed that this was an uphill battle, that it had never been done before, that it was something that there was no precedence for. And so we had a really hard couple of weeks looking at the case precedents. And again, going back to the Communications Decency Act, you can open Twitter, Google Communications Decency Act, the CDA 230. It is definitely a hot topic in the news every single day. But I would submit to you all that I do not believe that the Communications Decency Act is the problem. The problem is the case law that has interpreted the Communications Decency Act. And that goes back to Zarin. And I have great conversation, and actually spoke on a panel with the lawyer that argued against Zarin case and handled the Zarin case. And I told him that it was my goal to be able to draw him on a case and overturn his precedents from 1996. And we've been successful. And I'd like to talk a little bit about how we've approached those cases. When we looked at the way that Zarin interpreted the Communications Decency Act, it was just wrong. I mean, I read it as just a flat wrong interpretation. And I looked at all of the cases that just continued to use Zarin as a crutch to get to the motion to dismiss. And it was just this cursory, nope, is it a tech related case? Is it saying tech did something wrong? They're protected, they have immunity. When in fact, the CDA does not mention immunity at all. It says no liability. But when you're doing an immunity analysis, you're doing a pleadings analysis out the gate. And so if you can't get past the pleading stage, you're never getting into discovery, you're never getting into the evidence side of it. And case after case just made this cursory dismissal saying tech company, alleging, treating them as a speaker, this very broad language where it's like, wait a minute, this isn't what we're alleging. This isn't what any of those cases was really alleging. Is not so much that we're treating them as a speaker in the defamation sense, which was what the purpose of the CDA was addressing. And the purpose of what Zarin was really trying to look at is defamation issues, somehow was then extended to abuse, stalking. You have the Grindr tragedy case, I call it a tragedy of an opinion in the Grindr case. And you see how it was morphed away from the original intent of the Communications Decency Act. And so we basically have come in back, we filed our first case against Facebook in 2018 in state court in Houston, Texas. We then filed 2 more in Houston, Texas. And we really just went head on and said that all of this case law for the past 20 plus years is flat wrong. And I can tell you one of my most fond memories is walking up the courthouse steps in Houston to our very first motion to dismiss. And I look at my appellate lawyer and I'm like, so what do I got? Do I have anything? Usually I'm getting fed the case law that I need to argue or the points I need to hit if I'm going to be handling argument. And he looks at me, I'll never forget it, Tim Lee with Ware Jackson, great appellate counsel. And he looked at me and he said, yeah, it's just Annie on the law. That's basically all it's going to be. And that's really all it was. And it was us making a decision as a team to argue common sense. Is it really the position of Congress back in 1996 when we were dealing with dial-up and AOL to say that when we are making allegations against Facebook for their independent acts in facilitating sex trafficking, that's what its purpose was, and that's what this case law was meant to be to say? And it was just talking in very plain language about this cannot be the state of the law, and that if it is, then it's not and shouldn't be the law today because it hasn't kept pace. It's a case where the law, and that's a very general term, has just not kept pace with technology. But what I would submit is it's not necessarily a statutory issue as much as it is a judicial interpretation issue. I would be fine with Section 230 staying exactly how it is, as long as we are able to continue to get past the pleading stage. And I think that this is a perfect opportunity for me to talk a little bit about our theory of what our case is. I will share with you all that we were the first team to defeat the Communications Decency Act in 3 trial courts, 3 appellate courts. The Texas Supreme Court unanimously decided in our favor, and so we have been able to continue. We have a trial date against Facebook in January. So let me back up momentarily and talk to you all just briefly about exactly what our theory is and what we're seeing. Because a lot of people are like, how does Facebook facilitate sex trafficking? And we approach that in a very plain language way as well. We know that Facebook, they admit that they monitor communications. They monitor your chats. They monitor WhatsApp. They screen everything that communicates. They connect people. It's Zuckerberg's testimony in April of 2018 to Congress, where he says, I make my money from advertisements, and we make our money from connecting people. There's a very, very famous internal communication that was linked from Facebook that talks about, yes, we connect people, and we continue to connect people even when we know those connections are bad. And so our case goes to the heart of, number one, false accounts. Facebook acknowledges that false accounts are often used in human trafficking, yet does nothing to verify their users. And the reason that they don't want to, our allegations are that they continue not to want to delete false accounts or verify identity because that's how they make money. They are selling the amount of users and the connections that those users make for profit, for advertisements. And it would, as Facebook has acknowledged in internal documents, that it would go directly to the heart of their business model if they were really truly monitoring these types of connections and these false accounts. We just heard Blumenthal and Senator Blackburn just recently in some of the Facebook Senate hearings talk about the false accounts and the role of false accounts in human trafficking. I can say that almost every case that we represent, there is a use of a false account on Facebook. And so our cases go to the heart of why is Facebook refusing to monitor these false accounts? The manner in which Facebook is connecting these predators with these victims. But it's also, I will share with you, one of the biggest concerns that we have with tech from the very beginning is how tech has revolutionized the access to buyers. One of the things people always look at, and one of the questions we get the most is how tech has evolved the human trafficking market, how law enforcement has evolved the human trafficking market. It is something where, back in the day, if you wanted to buy sex, if you were a sex buyer, you would have to go out, you would have to leave your home, you would have to either go to the street, you would have to go to a bar of some kind, and go out of your home to seek it. Well, one of the things tech has done, and what goes to the heart of our case, is they have basically put the demand market right there at the tips of your keyboard. You can go on and order someone directly to your home within a matter of minutes. And this is occurring on Facebook and Instagram and other tech companies instantly. It is available. You can search it up. We know that Facebook has the capability to review their marketplace, to review their users. We know that this is not being done in a hidden, secret manner, but is being done openly on their platform. And so it's really a question of, what does Facebook know? What do they do to prevent it? I will submit to you all that it's our position that Facebook does not do much of anything to really combat this. They love to say that they do, but in reality, we have not seen those measures put in place. And so our cases are proceeding to trial at this time to really try to address tech's own independent facilitation of sex trafficking and how they have contributed to the market. One of the other matters I would like to touch on is our other side of our cases. I think a lot of people understand and grasp the social media side of their cases, but we also have another tech effort that's going on to look at the companies that are working behind the scenes with some of these notorious sex trafficking sites. One of the stories that I'd like to share with you all that is really troubling to me is that you see we have cases pending against Salesforce. And a lot of people are like, what's Salesforce? Well, Salesforce is one of the biggest and brightest tech talents globally that operates a customer relationship management. You know, I'm from San Francisco originally, and so I knew who Salesforce was. My family lives there and the Salesforce Tower is there, so we're very familiar. People in Texas, not so much, but anybody out there who does any kind of marketing or really anything, a lot of them are operated off Salesforce. And our allegations, which are heavily disputed by Salesforce, is that Salesforce supported Backpage's efforts to market and attract new business. And so our second track of our case is not so much the social media forward facing, but what tech companies are doing to support not only the sale, but the buyers as well. And so we're really taking a hard look at these tech companies and what the bright line should be about what they know, when they know it, and what our expectations are. One of the things that was really disturbing to me is that you see law enforcement and the Department of Justice fighting so hard against Backpage, but then behind the scenes, our biggest and brightest tech companies are signing contracts with Carl Farrar, who was just arrested for pimping. And so we really have to take a hard look at how these companies are involved. Here we have law enforcement doing everything they can to fight Backpage and shut Backpage down, but how can they fight that fight with, well, on the very same day, the Senate is questioning the Backpage executives. We know that the tech companies are duplicating the Backpage data to be able to move it. And so we can't have this separation. We cannot have tech operating in this vacuum of lack of accountability and liability while law enforcement is doing everything that they can to the ends of the earth to fight it. They have to be able to be met somewhere. And so we truly believe that our cases are finally allowing us to shine the light on a lot of the activities that have been going on. I think something that is really troubling that we've seen in our litigation was, okay, April 2018, Backpage is seized, the Department of Justice shuts it down here in the United States, but it continues to operate overseas. We celebrate Craigslist shutting off human trafficking or their adult website, their adult section, yet that only occurred in the United States. Yet Craigslist and Salesforce continue to operate with other sites offshores. And so while these United States companies are saying, okay, in the United States, we're not doing it because we see Annie Mcadams and her team and we see the legislators cracking down on us, but we're going to continue to operate these bad actors overseas. We know that as soon as Backpage was shut down, a lot of our clients received emails from backpage2.com. And it was like, what's backpage2.com? How did they get all of the contact information? Well, it was a company out of Amsterdam using another company, MailChimp, to be able to mail blast out to the old Backpage clients saying, well, now that Backpage is closed, come out here. We absolutely cannot play this shell game. We absolutely cannot function in this realm of anti-human trafficking, if they're going to tell the United States, okay, we can seize it, we can shut it down, but the United States tech companies continue to globally operate human trafficking. It just can't occur. I certainly can continue to talk about this. I don't want to go over my time. So I'll wrap it up here. I do want to say that if there's anybody out there that has questions, please reach out to our team. If there's anybody that has cases that they're, trying to work on or get filed, we're an open door team. A lot of people are out there, and I always say, before you file a case, check with us. We're happy to offer our support for free. We want to make sure that, good cases make good law, and that the cases are filed that are going to continue to be successful, so we can support groups like Street Grace, and we can continue to support the US Congress as well as the state legislatures in their efforts, because we're really, really proud to stand with their efforts and law enforcement in the fight against anti-human trafficking. So please, open door policy, reach out to us at any time.
Hey, thank you so much, Annie. That was a fantastic presentation. I'm a nonprofit lawyer, and I feel like I've learned so much. It's been a long time since I've been in the courtroom, and it was just fascinating to hear that, and fascinating and really inspiring. The changes, the sort of systemic changes that you're achieving, piece by piece, getting these case law alterations. We've got a lot of questions. I'm going to winnow it down to 3 or 4, but one that keeps popping up is, you talked about the problems with social media, problem with these social media actors and their complicity in this. And of course, my kids, everyone's kids, use social media to some degree. And so to kind of summarize all these questions, what have you seen with respect to social media, and put a finer point on it? What should parents be looking for? How can they protect themselves in this world of bad actors who really have captivated our children?
That's a great question. And I think it's a question I get probably the most often from parents. I will tell you all, one of the things that we did when we first were looking at our cases, we were really tough on the parents. How did a parent allow their child to communicate with a stranger for over a year? We see a lot of the messaging and even the communications. I'm thinking it's really critical on the parents, right? Like, how did the parents, because I'm thinking, what are my juries going to think, right? And one of the things that I continue to see is that the parents said, I looked at the social media. I reviewed their conversations. I looked at who their friends were. And that goes to that fake account. They can use any picture. They can be any identity they want. They don't know that it's a 45-year-old man from another state behind this fake account. The problem is, people are not going to like the answer that I give. What can parents do? It's delete social media. Facebook and Instagram need to be deleted. There is no way to monitor it in an effective way. It is impossible to. I am under confidentiality orders, so we are fighting confidentiality to get the public a lot of this information. But I can assure you, if I can impart anything and say anything to everyone today, is social media, Facebook and Instagram, are not safe for your children, and they are not safe for you. And these companies, quite honestly, and as candidly as I can be, do not have a place in our society. It is my hope that one day we are able to share what our investigation has exposed to us. We are fighting that in the courts right now. But I can share with you that when parents do see what we know, what this company knew, when they knew it, what they do, how they do it, no child, no one should be on Facebook or Instagram. And I know that's not a popular answer. I'm not on it. My child's not on it. It's just not safe at this time.
Very sobering, but maybe that's the reality that we're living in. Another question that is coming up is around around compensation or victim restoration. What have you achieved for your clients? What are you trying to achieve? What do you, particularly with these tech companies, and in light of the allegations that you've made against them, what do you want them to do, both at the individual level for your plaintiffs, but also in general? What are you trying to achieve? What are we trying to get for this class of plaintiffs?
It's a great question, and I'll tell you that each one of our cases is individually filed. This is not a class action. I could go a whole nother session on why I don't like class actions, but I will tell you that this is an individually filed case on behalf of each client. And one of the things that we are asking for is compensation for the client so that they can receive the counseling. so that they can receive the medical care that they are needed. The trauma that these individual survivors have been through is lifelong, and they require lifelong care. You asked what is it that we want to see from the tech companies? I will tell you unequivocally, we are looking for a drastic and complete disruption in the status quo in which they operate. But second to that, I have grown tired of seeing organizations and hospitals, our tax dollars, Medicaid, Medicare, the Attorney General funds, having to try and shoulder the recovery process. The state of Texas, just up until recently, only had one facility for minor intervention. They had a license for 130 beds, but could only operate 20 beds for the entire state of Texas. What that meant is a minor in San Antonio was recovered by law enforcement. They would have to be driven to a location that we can't disclose in Houston that would house 20 beds for all of Texas, when we know that law enforcement is picking up near 20 in each city every night. The hospital district in Harris County, it shouldn't be our tax dollars shouldering the crisis and the burden of the public health crisis that tech has knowingly created and knowingly facilitated in their failure to monitor their sites and the failure to take any actions to protect these kids. So we are looking not only for a disruption in how they conduct day-to-day business, but we want to see the tech companies fund these efforts, these recovery efforts, the counseling, the medical crisis, and make sure that the people that have taken this money knowingly actually put it back into the community to alleviate the burden of our faith dollars, of your organization, of the hospital districts, and so forth. That's what we're hoping to see.
Wow, really well said. And this isn't so much of a question as sort of a comment I'm going to make. And one of the reasons I was so excited to have you part of this webinar is, as an attorney, you are so client focused. Right from the get-go, the very first time I met you, your objective was not to stack them high and settle them low. It was to get the best possible result for every client. And not only that, fashion the best case law. You have your firm and you have a plan, not to make a quick buck, but to make a difference in these people's lives and prevent this from happening. And I just wanted to say thank you so much for that. And I know you're also working on efforts to make sure that the other attorneys who come into this space, to the extent that you can, have the same attitude, where the attitude isn't, we're going to make this isn't asbestos litigation. We have a plaintiff, we have plaintiffs that need special care, and we have a system that needs to be changed.
That's exactly right. And I'll tell you, that's one of the things I sometimes say is we've handled big catastrophic injury cases, and we are familiar with the pressures of court. We're familiar with the pressures of clients and the pressures of their needs. One of the things that our team has not and was never familiar with was the pressure of honoring the work of others that have been in this space for a very, very long time. And it really came down to a career commitment for us of, we can continue to be successful in this personal injury space and try these cases, but are we going to, what's it going to be at the end of the day? Let's use our time, let's use our talent, let's use our treasure and honor not only the clients, but the people that created these laws. If we had picked up this law and created bad opinions, we knew that we had to give it everything that we had to support y'all's efforts as well.
And my final question, because we're running out of time, but this is another one that's come up, and I personally am very interested in the answer to this as well. You spoke about some of these companies that have been identified as, or at least alleged to have done these bad actions, that Congress has taken some action against them, that there's been hearings, and that the various federal law enforcement agencies have shut them down or enjoined them or stopped them from doing what they're doing. And yet they're still signing contracts and expanding overseas. And my question, or the question from the audience, is more or less, how do we not know about this? Usually human trafficking can't be splashed across the headlines enough, yet on the fact that these bad actors, particularly Facebook, not Facebook, particularly Backpage, is still operating in other countries is shocking, to the core. Why do you think there's a media silence on this? Why don't people know this?
The distortion of immunity, the way that tech has basically been able to operate in a vacuum, to where nobody has actually been able to say, raise your right hand with a consequence. We see the tech raise the right hand at Congress. What's the consequence? Civil justice exists for a reason. The 7th Amendment's in our Constitution for a reason. And it is an opportunity for us to actually reveal the truth. And I can tell you, with what we've seen, while we're still bound by confidentiality orders and we are going to battle, the public has only seen, I mean, I would say the tip of the iceberg, it's not even the tip. It's like a snowflake on the iceberg. And that is why these cases and getting past the motion to dismiss is so important, because open courts and the public needs to know. And I know that once that curtain is pulled and that light is on what the conduct is, these tech companies are going to learn and they're going to change their behaviors. But you cannot have zero accountability. Companies do not work in that space. It doesn't work for the protection of our society and our children. And I will tell you that a lot of people, to close, and I'll tell you, they'll say, well, what do you think? What are you going to negotiate? How does it negotiate? And quite honestly, the safety of our community is not negotiable. So we must win these cases and we must show the public what's going on. Once we do, we think that we're going to see the change that we need to see, just as we have in other industries.
For sure. Well, thank you so much for taking time out of your, I know is an incredibly busy schedule, to visit with us today. And thank you so much for the work that you're doing in this area.
Anything for y'all. Take care. Thank you for all y'all do.
Thanks, Annie.
Thanks.
I hope everyone really has enjoyed hearing from these two world-class attorneys on not only how they are working to achieve justice and restoration for individual survivors, but also how civil litigation plays a role in reforming the entire systems. That is, discouraging demand and discouraging businesses from getting involved in human trafficking or turning a blind eye to human trafficking. I know not everyone is comfortable with systemic change through civil litigation, and I get that. But it's also important to note that we have laws in place. We don't have all of the resources in a public sense, in a government sense, to always treat this crime systemically like we should. And so this is simply another facet of how these laws can be applied, how people can be disincentivized from activities that encourage or profit from human trafficking, and how also buyers and demand can be diminished using civil litigation strategies. So how in your state, what should you be looking at? What are some policy ideas you can have to make these sorts of cases more viable? And the first thing to look at is whether your state has a separate civil action for trafficking victims. If they don't, I strongly suggest you track the TVPA. Most states have in this regard. The one that I'm most familiar with is Texas's Chapter 98. It tracks the TVPA very closely. And of course, TVPA means Trafficking Victims Protection Act. So the very first thing you want to do is to have a actual cause of action codified in your law, so survivors don't have to use traditional tort remedies like negligence or something else, or assault, which may not really get to all of the facts and all of the abuse and the unique circumstances that trafficking victims are going to find themselves in. So you want a unique, discrete statute that allows a trafficking survivor to sue not only her trafficker, but buyers and anyone who has participated in this venture, profited from the human trafficking, who knew or should have known what was going on. A big part of this, an important thing, as we get a little more granular here, is that it can't be a defense within this statute. It needs to be spelled out that trafficking victims can bring the civil cause of action regardless of whether their pimp has been prosecuted. Their trafficker may or may not have ever been arrested, right? No one who actually trafficked this person may have ever been truly brought to justice, but the hotel or the internet site or the truck stop or whoever else turned a blind eye or willingly participated in this should still be on the hook to restore the survivor, because it couldn't have happened without them. So it needs to be clear in this statute that regardless of whether anybody's been criminally punished, the survivor can still bring this forward. And it's also important because the burdens of proof are so very different in criminal and civil courts. In a criminal court, I think, as we all know, it's beyond a reasonable doubt. Well, that's not the case in civil law. In civil law, it's generally a preponderance of the evidence. And the best way I've ever seen this demonstrated was by an attorney who put out 2 stacks of paper of 50 each. And he said, right now, the evidence is equal on both sides. But if I take one piece from one stack and move it to the other, that's a preponderance of evidence. We now have a preponderance of evidence on this side. So it's very, very different. And the civil statute should reflect that. Another key point when you're designing or improving your state statute in this regard is looking at liability schemes. Pat touched on this a little bit. You'd have to look at your state and see what your state generally defaults to, whether it's proportionate liability or joint or several or another liability scheme. We look at joint, we want joint and several liability, which means if you've got multiple tortfeasors, you've got multiple bad actors, You've had a hotel and a security firm and a limo service that are all complicit. They knew human trafficking was occurring. And you sue them all, but the limo service and the security company are bankrupt. The hotel has got plenty of money. Well, in joint and several liability, you can collect all the damages from one defendant. If that one defendant can pay, that's who's going to pay. But under a proportionate liability scheme, it might be 20% hotel, 30% limo, and 50% security. Well, you can only collect that amount. That you're capped. I can only get 50%. I can only get 20% for the hotel. And so you want joint and several liability. And if your state doesn't have a joint and several liability scheme, you want to carve out in this statute, spell it out, joint and several liability for claims made under the statute. The next one is a little bit controversial, but very, very important. It's veil piercing. Texas, I think, is the only state that has a veil piercing statute that's part of their cause of action for human trafficking victims. So what is veil piercing? I'll try to make this as easy as possible, but it has to do with the corporate veil that comes into being when you form a corporation. If I formed Jamie Co. and I'm going to sell widgets, well, maybe I've made a little money with Jamie Co., but I'm a pretty bad businessman, true. And I've run up a lot of debt. I'm not able to pay my suppliers, and I'm not able to get my product out to my vendors, and Jamie Co. is folding, and I owe a bunch of people a lot of money. Well, as long as I've been straightforward with Jamie Co. and I haven't defrauded anyone or acted in some sort of illegal way, my personal assets, assuming I had some, would not be subject to any judgment if I got sued. So my supplier sues Jamie Co. He can collect whatever is left in Jamie Co.'s coffers, but he can't come after me for my speedboat or my second house. I don't have either one of these things, but we're pretending, right? If you have veil piercing, if circumstances or facts or a statute allows veil piercing to occur, well, all of a sudden that corporate veil that protected all of my personal stuff from my business stuff is pierced. It's gone. That protection is gone. And all of a sudden that same creditor who's after me to recover, or after Jamie Co. can now say, well, I see Jamie Co. doesn't have much left in their bank account, but I'm going to reach beyond that into Jamie's personal stuff and get it. The reason veil piercing is important is because it will allow survivors, one, to be fully restored when there's a shell company, and it also makes companies pay attention. A lot of states don't like this, especially red states don't like veil piercing. They want to protect their businesses, and I understand that perfectly. That's why we advocate for a limited veil piercing statute that occurs only in this circumstance. Did an officer or director have personal knowledge that human trafficking was going on, or should he or she have known? Well, in that case, those personal assets should be subject in case the company cannot fully satisfy the judgment. And last, I want to talk a little bit about shield laws. These protect survivors who are on the stand. You probably heard of rape shield laws, right? Where you cannot bring up a survivor or a rape victim's personal sexual history, for example, bring it up on the stand to somehow justify her being raped, or saying that she deserved having this happen, or she somehow brought it on herself. You want these same sort of shield laws for trafficking survivors, both on the criminal side, and you want them on the civil side as well. I hope everyone enjoyed that little policy roundup, and I want everyone to know that if you're interested in amending or improving your state statute, or your state doesn't have a statute and you want a sounding board, or you just like to talk some of this stuff through, we're always available for that. My email is jamie@streetgrace.org. So if you would like some assistance or just talking through what your state statute looks like or what it could be, again, jamie@streetgrace.org. We're always happy to work with folks to improve the laws inside their state. And that concludes today's presentations. I want to thank everyone so much for being part of this webinar series and joining us here today. Again, I want to thank our fantastic speakers, Annie Mcadams and Pat McDonough, for all the work they do. And another huge heartfelt thank you to NCOSE and Global Emancipation Network for their sponsorship of our webinar series. Last, I'm going to remind you one more time, we've got the QR code coming up. Please take just a second to scan that in and take that little survey. It really does help us improve this and bring the most meaningful and best webinars to you. We're going to be having another one this summer, so stay tuned for that. If you're here today, you're going to get the invite for the next one. We're going to be looking at the illicit massage business and its intersection with demand. Again, thank you all so much for joining us here today, and look forward to seeing you all again. Thanks.